Corporation of Kenya and 5 others versus Loyal Media Services and 5 others, stated that the Constitution should be interpreted in a holistic manner within its context and in its spirit. In Lena Concheral and others versus Chief Justice of the Supreme Court of Kenya and others, the court restated the principle that the Constitution should be given a purposive interpretation where all provisions are read as a whole, with each provision sustaining the other. The following passage appears in Gatirao Peter Munya versus Dixon Mwenda Kitheji and 2 others in Supreme Court Petition number 26 of 2014. I shall not read it. This principle was restated by the Court of Appeal in Attorney General versus Law Society of Kenya and 4 others, 2018, and a number of other decisions that we have considered. I shall not read them out. The Supreme Court in Samuel Kamau Macharia and another versus Kenya Commercial Bank Limited and 2 others held as follows, and I quote, "At the outset, it is important to note that a constitution is not necessarily subject to the same principles against retroactivity as ordinary legislation. A constitution looks forward and backward, vertically and horizontally, as it seeks to re-engineer the social order in quest of its legitimate object of rendering political goods." I shall not read the rest of that paragraph. Applying those principles to the matter at hand, we find further as follows. The history of the office of CAS is fairly recent, having been first established on the 24th of January 2018. However, on 20th April 2021, the High Court in Okiya Lomtata Okoitil and another, Supra, declared the office to be unconstitutional. That decision was stayed by the Court of Appeal in Public Service Commission and 72 others versus Okiya Lomtata and 4 others. The main appeal is still pending. In granting the stay, the learned judges of the Court of Appeal found, and I quote, that public interest underpinning the substratum of the intended appeal would demand that we affirm the interim orders in terms of prayers 2 and 3 of the application issued on the 15th of June 2021, and which we hereby do. Cost of the application to abide the outcome of the intended appeal, unquote. To fully appreciate the terms of the order of stay, we looked at the wording of prayers 2 and 3 of the appellant's notice of motion dated the 29th of April 2021, brought under Rules 5, 2B, and 47 of the Court of Appeal Rules. They were couched in the following terms. 1, that pending hearing and determination of this application, there be a stay of the judgment and order of the High Court, Murima J, made on 20th of April 2021. For the avoidance of doubt, pending the hearing and determination of this application, the offices and the individuals currently holding the offices of Chief Administrative Secretary, Cabinet Secretary, and Principal Secretary shall not in any manner be affected by the judgment on order, and the Honorable Attorney General shall not be required to file an affidavit in the matter within 30 days of the judgment or at any time. And 2, pending the hearing and determination of this application, the High Court shall not take any steps in enforcing the judgment or order made on 20th April 2021 in High Court Constitutional Petition number 33 of 2018 as consolidated with High Court Constitutional Petition number 42 of 2018. For the avoidance of doubt, pending the hearing and determination of this application, there be a stay of proceedings before the High Court, and an order do issue that the Honorable Deputy Registrar shall not schedule the matter for mention, and the High Court shall not mention the matter to issue any further orders, unquote. It is our considered opinion that the above stay did not reverse the findings or declarations or orders of Murima J, that the office of CAS as then constituted was unconstitutional. The learned judges only granted a stay of execution in the terms of prayers 2 and 3 that we have set out above. Furthermore, the main appeal is pending. We have then closely studied the decision of the Employment and Labour Relations Court in Law Society of Kenya versus the Public Service Commission and the Honourable Attorney General, Petition 174 of 2022. The respondents have relied on that decision for their proposition that the learned judge, Baru J, found the advertisement calling for public comment and the creation of the office to be lawful. We fully appreciate that we cannot review or stand on appeal over a decision of a court of concurrent jurisdiction. However, we are also alive to the fact that we are not bound by the decisions of Murima J and Baru J above. The suit before the ELRC was challenging the validity of the advertisement by the PSC dated the 21st of September 2022, inviting public views on the establishment of a new office for CAS. The petition was dismissed. For the avoidance of doubt, the prayers as set out in the face of the judgment were: A declaration that the advert of the first respondent dated 21st September 2022 is illegal and irregular for violation of Section 27 of the Public Service Commission Act 2017, insofar as it fails to include fundamental details under the said Section 27 subsection 1 to enable the public to make meaningful and informed contributions towards the establishment of the office of CAS. B, a declaration that the advert of the first respondent dated 21st September 2022 is illegal, irregular, and unconstitutional for violating Article 201, Sub-Article D of the Constitution, as it seeks to establish an office in the public service with duplicity of roles as that of Principal Secretary, contrary to the principles of public finance. C, an order that the said advert of 21st September 2022 be declared a nullity, as it fails to provide crucial information that enables the public to make informed contributions in the establishment of the office of CAS. D, an order that the first respondent be required to provide information provided for under Section 27, subsection 1 of the PSC Act in any public participation before the establishment of public office. And lastly, E, each party to bear its own cost. The learned judge of the ELRC interpreted the stay by the Court of Appeal in Public Service Commission and 72 others versus Okiya Mtatal and 4 others as follows. The first respondent, PSC, took into account that after the Court of Appeal stayed the High Court judgment addressed above, parties then reverted to the position subsisting prior to the judgment, unquote. The learned judge then went on to find that all the legal parameters for establishment of the office were met. It is imperative to note that the Law Society of Kenya did not appeal the dismissal of its petition by the Employment and Labour Relations Court. We are cognizant that the courts established by Article 162 of the Constitution have the same status as the High Court. As we have stated earlier, whereas we have no power to review the decision of a judge of concurrent jurisdiction, we are equally not bound by it. Having set out the approach taken by Baru J above, we are of a different view, especially because of the findings by Murima J that the office of CAS is unconstitutional, have not been set aside and are pending appeal. For instance, Murima J found that the procedure in Section 47 of the PSC Act recommending appointment of PAS of peace. Let me read that again. For instance, Murima J. found that the procedure in Section 47 of the PSC Act recommending appointment of permanent secretaries applied mutatis mutandis to CASs. He held as follows, and I will not read the paragraph. Following the above judgment, and on 21st September 2022, the PSC resolved to abolish the office of CAS altogether and to commence the process of creating a new one. The record shows that PSC was prompted by a proposal from His Excellency the President to establish the office in accordance with Article 132, 4A of the Constitution. To be precise, on 19th September 2022, the head of state and government, through the head of public service, wrote to PSC, and I quote, to establish the office of Chief Administrative Secretary within the ranks of the public service, unquote. PSC concurred with the proposal on the 11th of October 2022. On the same day, the head of public service acknowledged receipt of the letter and requested the PSC to advertise for 23 positions of CASs. A copy of that letter is attached to the affidavit of the first petitioner, marked EKM 001. We have set out in another part of this judgment the timelines up to the point the new CASs took their oath of office. According to the affidavit of Henry Rotich, sworn on the 19th of October 2022, the PSC resolved, and I quote, to comply, unquote, as much as it could with the findings of Murima J. in the Okia case, notwithstanding the order of stay and the pending appeal. The PSC placed an advertisement on 22nd September 2022 in the local dailies, calling for comments from the public on the proposal to establish the office. Those comments were to be received on or before the 6th of October 2022. As we have mentioned earlier, that was the advertisement that was challenged by the Law Society of Kenya in the Employment and Labor Relations Court. We have no doubt that Article 132, Sub-Article 4A of the Constitution expressly grants His Excellency the President power to create an office in the public service. But in doing so, he and the PSC are bound to follow the requirements of the Constitution. We agree with Murima J. in the Okia case, Supra, where he stated, and I have quoted, but the following lines are important: the procedure for establishing an office in public service has its basis in the Constitution and law. Article 132, 4A of the Constitution provides that the President may perform any other executive function provided for in this Constitution, all in national legislation, and, except as otherwise provided for in this Constitution, may establish an office in the public service, in accordance with the recommendation of the Public Service Commission. In undertaking such duties, the President and the PSC must comply with the Constitution. That is the calling in Articles 3 and 10 of the Constitution, unquote. Given the nature of the present dispute, it was imperative for the Public Service Commission to file a replying affidavit clarifying the role it played in evaluating the request by His Excellency the President and seeking any advice from necessary bodies such as the SRC and in rendering its final advice to the President. Being a constitutional commission, it was to be guided in its decisions by the principles outlined in Article 10 for its actions. Granted that background, the failure by PSC to file a replying affidavit answering the specific allegations leveled against it, and to choose instead to rely on the defense by other parties or their depositions was a serious omission. It but remains that some allegations by the petitioners against the PSC were not sufficiently rebutted. See General Irene Wagari-Gachero and 6 others, 2017. We are, however, alive to the fact that the PSC is not the sole respondent here, and that the affidavit of Mr. Felix Koske, Chief of Staff and Head of Public Service in the Office of the President, sworn on the 24th of April 2023, and filed by the Attorney General, second respondent, is useful to the case of the Public Service Commission. But it certainly cannot provide a full answer to all the allegations made against it by the 4 petitioners. The PSC, in its submissions before us, sought to rely on the affidavit of Simon Rotich, sworn on the 19th of October 2022, in response to Nairobi ELRC petition number E174 of 2022, and next to the affidavit of the first petitioner in this consolidated petition. That affidavit sheds some light on the process of creation of the new Office of CAS and the public participation. It is not lost on us, however, that events were then at preliminary stages, and in fact, the advertisement seeking public views on the proposed office became the subject of the suit in the ELRC case. We have closely analyzed the newly created Office of CAS. The office falls somewhere between 2 constitutional or state offices, that of the Cabinet Secretary, CS, and that of the Principal Secretary, PS. Those 2 officers undergo vetting and approval by Parliament, but the CASs have been appointed and sworn into office without parliamentary approval. According to the opinion of the Speaker of the National Assembly, there was no statutory or legal framework for Parliament to vet the new 50 CASs under the Public Appointments Parliamentary Approval Act 2011. We are aware that not every holder of high or state office undergoes parliamentary approval. But the problem here is that the CASs are, for all purposes, assistant cabinet secretaries, reporting directly to the CS. The PS is relegated to the position where he reports to the CAS and the CS. Doubt is completely removed by their job description in Gazette Notice number 12432 of 12 October 2022, and duties specified therein, and the fact the CAS will be in a higher job group, CSG3, than the PS. The Gazette Notice gave particulars of the office as follows: duties and responsibility. A Chief Administrative Secretary will be responsible to the Cabinet Secretary in the performance of his or her duties. Specific duties and responsibilities shall include: A. Responding to issues/questions touching on the portfolio assigned to the office. B. Providing liaison with the National Assembly and Senate. Providing liaison with county governments on matters of concurrent mandate. Providing interministerial sectoral coordination. Representing the Cabinet Secretary at any meeting as instructed by the Cabinet Secretary. And D. Executing any other duties and responsibilities specifically assigned to the office by the Cabinet Secretary in furtherance of the interest of the Ministry. Terms of service. A Chief Administrative Secretary will serve on contract as determined by the appointing authority. B. This position is graded at CSG3 in the public service. The remuneration and benefits commensurate to this level will be applicable, unquote. We also find that whereas His Excellency the President can establish a state office within the ranks of the public service, it requires approval by the National Assembly. Such approval may be achieved by enactment of a statute which provides for the same and further provide an appropriate framework for a cap on the numbers of CASs if necessary. In the end, we are not satisfied that the newly created Office of CAS meets constitutional thresholds. Having reached the above conclusion, we are nevertheless still minded to address the issue of numbers. We note that the initial approved complement rose from 23 CASs to 50. By virtue of their salary and hierarchy, we agree with the fourth petitioner that the creation of the offices would come at a substantial cost to the public. The respondents urged us to find that the office is separate from numbers, and that once the office was legally in place, it was beyond the court to look into the numbers or the accompanying wage bill, and that the task fell to other bodies such as Parliament, Controller of Budget, or the Salaries and Remuneration Commission. We have addressed that issue in a separate part of this judgment. The respondents and interested parties urged us to find that once the Office of CAS was established, the complement, all number of officers, was at the discretion of either the PSC or His Excellency the President. Our attention was drawn to the case of the Judicial Service Commission, which recently advertised for 6 posts of Court of Appeal judges but hired 7. We distinguished the above example from the present scenario on the basis that at the material time there was a vacancy, and JSC did not overshoot the ceiling of 30 judges set for the Court of Appeal. The respondents and interested parties also relied on the decision in Sheria Mutaani na Shadrach Waboi Supra. The petitioner, in that case, challenged the employment of 350 persons by the PSC for the position of Accountant 2 in the National Treasury, but when the advertised vacancies were only 250, the petition was dismissed. But that decision can be distinguished for 2 reasons. Firstly, in the instant consolidated petition, the office created is a high public office with substantial salaries and perks. And secondly, the Sheria Mtaani case was dealing with hiring of lower cadre of public officers, being accountants too. As we pointed out earlier, in interpreting the Constitution, this court is bound to adopt a purposive approach which seeks to give effect to the true purpose of legislation, unquote, and may examine, and I quote, material that bears upon the background against which the legislation was created. See Gatirao Peter Munya versus Dixon Mwenda Gideji. Kenya had for many years a cabinet consisting of ministers and assistant ministers whose composition or numbers was largely at the discretion of the president. The public clamor for control of the size of the executive was reflected in the draft Constitution of Kenya 2005 by the Constitution of Kenya Review Commission. In the proposed Constitution of Kenya 2005, adopted at the BAMBA's Constitutional Conference on the 15th of March 2004, it was provided for as follows. The President, in accordance with this Constitution, shall appoint and may dismiss A, the Cabinet consisting of 1, the Prime Minister, 2, the 2 Deputy Prime Ministers nominated by the Prime Minister, 3, not less than 15 and not more than 20 ministers nominated by the Prime Minister, and then B, not less than 15 and not more than 20 deputy ministers nominated by the Prime Minister. The number of assistant ministers in the proposed constitution thus matched that of the ministers. Murima J. in the Okia case had also the following to say on that subject, and I shall not read it. The final report of the Committee of Experts, dated the 11th of October 2010, notes that Kenyans wanted, and I quote, that there be a clear distinction between offices of state and offices of government, unquote. Following public debates, the position of the Assistant Minister was abolished altogether and did not make it to the Constitution of Kenya 2010. It is thus not surprising that the size of the Cabinet Secretaries is now capped at 22. Article 152 of the Constitution provides that the Cabinet shall comprise of A, the President, B, the Deputy President, C, the Attorney General, and D, not fewer than 14 and not more than 22 Cabinet Secretaries. It is therefore our considered view that the creation of a similar office to the Assistant Minister, now in name of CAS, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 Cabinet Secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs. Doubt is erased by the following other facts. In the letter of 11th October 2022 by Dr. Joseph Kenywa, Head of Public Service, to the PSC, the Head of State requested the PSC to declare 23 vacancies for CASs. We note, however, that the special issue of Kenya Gazette Notice number 12432, dated 12th of October 2022, and the media advertisement the following day, calling for applications from suitable candidates, did not set the number of vacancies. Furthermore, the stay in the Court of Appeal preserved the original office created on 24th January 2018. Once that office was abolished on 21st September 2022, the newly created office and complement of 23 office holders could no longer benefit from that stay. Accordingly, the newly created office and fresh complement of 50 had to comply with the Constitution and the criteria set out earlier in Okia's case in order to be lawfully established. They did not comply. For the avoidance of doubt, the entire complement of 50 CASs is therefore unconstitutional. I'll now ask my learned sister, Lady Justice Ongudi, to deal with the next issue.
So the next issue is on the financial implications of the creation of this office and whether the same is a waste of public funds contrary